Good morning, and thank you for joining us this morning for today's webinar on sextortion, the impact on judging and courts. My name is Sarah McCoubrey. I am a judicial integrity strategist with the Judicial Integrity Network, ASEAN region, and I am delighted to welcome you all this morning. This event is a partnership, the first partnership we've done between the International Association of Women Judges and JIN ASEAN. And the two organizations are really excited to partner together because we have each been working in the region on different and yet related issues, and we're pleased to be partnering together. We both work as organizations to raise awareness of gender issues in the judicial context. JIN ASEAN's surveying in 2021 and 2022 of judges revealed the impact and importance of gender issues in the courtroom. And when we looked at that, we learned about the ways that judges are experiencing gendered issues, but also the way that gendered issues are playing out in the courtroom itself and in the court administration. This event is a chance for us to focus specifically on sextortion, or corruption that is focused on the gendered aspect of sexual favors or sexual pressure. And this happens both in the court process itself, and also when judges are called upon to decide on or adjudicate cases of corruption and sextortion. By co-sponsoring this event, IAWJ and JIN ASEAN are inviting judges, judiciaries, court administrators, academics to come together and learn and discuss these important issues, drawing on the expertise across the region, together with AIWJ's global focus for women judges and JIN ASEAN's regional peer-to-peer focus to advance this conversation and support judges in this way. Today, we have a great panel, and I'm shortly going to introduce them. They are going to each give a short presentation about the issue and about what their court or organization is doing about it. And then we're going to open it up for a Q&A session. And so I'm going to make sure before I hand it over that we've got the logistics taken care of. First of all, I see someone here. We should have audio working just fine. So if someone is having trouble hearing, perhaps adjust the volume settings on your own computer. Audio should be working. We will be using questions through the Q&A feature. And so through the Q&A feature, please feel free to post your questions. And at the Q&A section, we will address as many of them as possible. You'll see the Q&A feature down below. As we get started here, if you have any other technical issues and you post those in, myself or one of my colleagues will help you to troubleshoot those, and we'll leave our panelists to focus on the important discussion that we're having here today. It's my pleasure to start off by introducing our speakers, and then I will hand it over to our moderator to set up the conversation itself. Today's session is going to be moderated by Nancy Hendry. Nancy is a senior advisor of the International Association of Women Judges, and she has represented the organization as a speaker, a researcher, and an advocate on these issues. She did much of the groundbreaking work on behalf of IWJ to start this conversation about sextortion globally. Prior to her involvement with IWJ, Nancy studied law at Stanford Law School and then pursued a very dynamic career in the US Peace Corps, acting as general counsel, serving as vice president and deputy general counsel for the Public Broadcasting Service, as well as teaching and acting as special general counsel, practicing in private practice as an attorney. And throughout all of these, she has brought her leadership and expertise to IAWJ and her understanding of and rich experience with gendered issues. We're honored to have her moderating our discussion today. We will also have with us Shamala Gomez, Executive Director at the Center for Equality and Justice in Sri Lanka. She founded the center and works there to focus on issues of post-war and women, specifically reconciliation, transitional justice, including reparations, and how to focus on taking people to account for behaviors in these processes. Ms. Gomez taught law at the Faculty of Law at the University of Colombo for 8 years and was also gender advisor to the UN office in Colombo. As a Fulbright scholar with an LLB from the University of Colombo and a master's in law from Georgetown University in Washington, she is a visiting researcher at Harvard Law School in 2021 and 2022 and continues to advance her scholarly work on these issues. Next, we will have Macy Sabadaya, component manager with the USAID Integris/Chematron project. Macy is a justice sector, rule of law, and anti-corruption specialist with over 15 years of experience working in reform projects in Indonesia. She currently is working on this USAID funded project that is focusing on anti-corruption, and it is a partnership for governance reform. Previously, she worked at the Asia Foundation, as well as with the judicial reform team of Indonesia's Supreme Court, and as a senior researcher in the Indonesia Judicial Monitoring Society at the Faculty of Law. Macy holds master's degree from the University of Sydney and a bachelor degree of law from the University of Indonesia. And third, we will have Achi Astravani, coordinator of the Judicial Reform Team Office for the Supreme Court of Indonesia. She is currently special staff to the Vice Chief Justice and coordinator of the team itself. Her office is responsible for supporting the Supreme Court in implementing the reform agenda that the court has, released a blueprint for judicial reform in 2003 that includes developing and evaluating Supreme Court policies and responding to the needs and aspirations of the justice seekers and other legitimate stakeholders of the judiciary. Prior to being appointed to this current position, she served as Director Executive for the Indonesian Institute of Independence of the Judiciary, and she obtained her bachelor degree from the Faculty of Law at the University of Indonesia and a master's in public policy management from the Melbourne School of Government. In this conversation, Achi will focus on the interests of the court and the discussions of sextortion being taken by the Supreme Court. I want to thank all of our speakers, and I'm going to hand it over to Nancy to get our conversation started. And I look forward to all of your questions as we move through the event. Over to you, Nancy.
Thank you, Sarah. So to set the stage for the discussion with our panelists and questions from the audience, I'd like to begin with just a little background on the transformative impact judges can have when they shine a light on what have been gender blind spots in the justice system. And the IAWJ's work on sextortion is really a powerful case in point. People have long abused power for sex, but it occupied a blind spot in anti-corruption and gender equality efforts. In 2008, IAWJ members shared their concerns about sexual abuses that were occurring with seeming impunity. The circumstances differed: sex in exchange for passage across the border, for delivering medicine to a prison inmate, a favorable court decision, a passing grade, but all involved a common pattern of abuse of authority in exchange for sex. At the time, there was no name for this pattern. So the IAWJ coined the term sextortion to underscore that such abuses are not only a form of sexual exploitation, but also a form of corruption. It's difficult to overstate the importance of giving this phenomenon a name and a clear and consistent definition. The lack of a name contributed to sextortion's invisibility. Everyone knew it existed, but without a name, no one talked about it, gathered data, worked to raise awareness, developed strategies for combating it, or drafted laws or codes of conduct that clearly addressed it. In little more than a decade, that has changed. Sextortion has become part of the international anti-corruption discourse. People understand that it refers to a form of corruption in which sex is the currency of the bribe. And we have a common language for talking about it, taking steps to address it, and sharing information and good practices. What we've learned is that sextortion is a global phenomenon, not limited to certain countries or regions, and that it affects virtually every sector, from provision of basic government services to education, healthcare, employment, land ownership, humanitarian aid, law enforcement, and even access to justice. Given how pervasive sextortion is, how had we missed such an important piece of the corruption picture for so long? The absence of a gender perspective played a major role in that failure. It is perhaps not an accident that an association of women judges, whose mission includes promoting access to justice for women, would be the one to see the global pattern and give it a name. One of the lessons learned has been the extent to which gender inequality and corruption are mutually reinforcing. The power dynamic that contributes to gender inequality places those who are most vulnerable in a position where they are least able to resist corrupt demands. Judges need to understand these issues, not only because they may arise in cases that come before them, but also because courts as institutions confront the same gender-related problems that plague the rest of society. In fact, one of the cases that initially sparked the IAWJ's interest in sextortion involved a woman in Ecuador who was propositioned by the judge hearing her child support claim. Another case of sextortion involved a Canadian immigration adjudicator named Steve Ellis and a South Korean woman seeking refugee status. Several weeks after hearing her case, Ellis asked to meet her at a coffee shop. Her fiancé secretly recorded and videotaped the meeting. At the meeting, Ellis told the woman he had planned to deny her application, but if they could do things on the side and she kept the affair secret, he could issue a favorable decision. The couple gave the recordings to the Immigration and Refugee Board and the media. Ellis was ultimately convicted of breach of trust and agreeing to accept a benefit in violation of the Immigration and Refugee Protection Act. Subsequent disciplinary proceedings found that he behaved with an utter lack of integrity. Quote, he offered to exchange a favorable quasi-judicial decision for sex rather than deciding it on its merits. There are, of course, any number of ways in which judges might abuse their authority and manipulate the justice system in exchange for sex. For example, a judge in Tennessee was charged with erasing court and traffic fines in exchange for sex with two women. And another judge offered to intervene in a felony case filed against a woman's friend and have the case transferred to his court if the woman would have sex with him. While sextortion has a disparate impact on women, men can also be victims. A judge in Arkansas was indicted on bribery charges for offering leniency to male defendants in exchange for posing for compromising photos or being paddled by him. In fact, the judge's conduct dated back almost 40 years to his time as a prosecutor. One man alleged that he had twice rebuffed the sexual overtures and was told, "You remember, I'm the prosecutor. I can help you or I can hurt you. No one will know." And after being rebuffed, the prosecutor indeed took the case to trial and sought and obtained a life sentence for the man. Sextortion can not only affect those who appear before the court, but also those who work within it. In the Philippines, a judge demanded that in exchange for signing a young woman's appointment papers to work for the court, she would come to his office every day to give him a kiss. In convicting him, the court observed, And this was in the absence of a sextortion statute, so he was charged with sexual harassment. The gravamen of the offense is not the violation of the employee's sexuality, but the abuse of power by the employer or superior. And in fact, the Supreme Court subsequently found that his conduct violated the Code of Judicial Conduct and dismissed him from the service. As part of the IAWJ's initial sextortion project, the Tanzanian women judges were the first to recognize that sextortion is not only a violation of law, but also of judicial ethics. Judicial integrity is a broad concept. However, a key element of that integrity is a justice system that operates in a transparent and non-corrupt manner to serve the interests of justice rather than the personal interests of judges or court personnel. From the standpoint of transparency and accountability, it matters not whether a judge or other official renders a favorable decision in exchange for cash or in exchange for sex. Both are equally lacking in integrity. Judicial integrity begins, of course, with a judge's treatment of those before the court and his responsibility to assure that they treat each other with respect as well. But it's not limited to courtroom conduct and judicial decision-making. Judges also have responsibility for administering their courts and assuring the integrity not only of the way they, as judges, deal with their colleagues and subordinates, but also the way court personnel deal with each other and with the public. In Tanzania, our member judges told us about a sextortion case that involved a court employee who supervised an office of about 10 women. The matter first came to people's attention because of the high incidence of illness in the office. Upon further investigation, it was learned that if you wanted to earn overtime pay, you had to sleep with the male supervisor. The male supervisor, who had HIV, spread the infection to all his female employees with tragic consequences. And that experience motivated the women judges to conduct seminars on sextortion for employees in every one of the country's high court centers, just to let those employees know that these women judges were there for them and would support them from being abused. While it might seem obvious that justice sector actors should not engage in sextortion, regrettably, some do. While it might seem equally obvious that sextortion violates fundamental ethical standards, it may not be so readily apparent to those charged with enforcing ethical obligations. A case involving a Wisconsin prosecutor illustrates the importance of having ethical standards that explicitly address sextortion. In that case, both the prosecutor and ethics officials initially saw nothing wrong with using his position as a district attorney to pressure a domestic violence victim into a sexual relationship. After a meeting with the woman, at which she vigorously opposed reducing the felony charges against the man who had tried to strangle her, the prosecutor sent her 30 increasingly explicit text messages describing her as a hot nymph and asking whether she likes secret contact with an older married DA. The riskier, the better. After 3 days, she went to the police, concerned that he might not prosecute her abuser to the fullest extent. The matter was referred to the Office of Lawyer Regulation, which declined to open an investigation, explaining that while inappropriate, the text did not appear to involve possible professional misconduct. The prosecutor claimed he was only providing a few compliments to the young lady. 10 months later, this story found its way into the press, and there was, of course, a public uproar, and the ethics inquiry was reopened, this time finding 11 possible violations. The prosecutor was ultimately forced to resign and had his law license suspended. But absent the public outcry, nothing would have happened. So we need to raise awareness about sextortion and incorporate it in ethical codes and training. First, so there will be no confusion on the part of attorneys or judges or other justice sector actors between providing compliments to a young lady and abuse of their position of power. And second, so that those charged with professional discipline won't turn a blind eye when confronted with those abuses of power. Judicial leadership in this is key. Through the Global Judicial Integrity Network, IAWJ has focused attention on the need for judicial codes of conduct and education materials to address sextortion with greater clarity. Gender issues implicate, in some measure, each of the 6 values in the Bangalore Principles of Judicial Conduct: independence, impartiality, integrity, propriety, equality, and competence and diligence. However, most codes of judicial conduct do not address these issues with the specificity needed for judges to understand which types of conduct are acceptable and which are not. It's important not only to have clear standards of conduct, but to communicate them broadly. A significant challenge in providing accountability is the reluctance to report gender-related misconduct. Many factors conspire to keep women from reporting sextortion and demanding that perpetrators be held accountable. And once a complaint is received, there needs to be an effective, fair, and transparent disciplinary mechanism for investigating and taking corrective action. Ongoing monitoring and assessment are also important in understanding the scope and extent of any gender-related misconduct, such as sextortion. But above all, it's important to share information and good practices, and in turn, to share those insights and practices with judicial colleagues and use them to influence courthouse practices and policies, including employment policies, judicial codes of conduct, provide input into legal reform efforts, and model gender-inclusive judicial attitudes and behavior. Addressing sextortion remains a monumental task, but we've changed the conversation, and that is no small feat. Today, we are really fortunate to have the opportunity to continue that conversation with 3 panelists who have experience in addressing sextortion in the region. And let me turn first to Shamala to talk about her work in Sri Lanka. Shamala.
Thank you, Nancy. Again, also thank you to Jean ASEAN and the IAWJ for having this panel discussion, this very timely discussion. And thank you for inviting me to speak a few words here. Yes, so as Nancy mentioned prior to this, my work on sexual or sextortion has been for many years. And just to give you a bit of background to this work, and the reason why we started working on this issue is because many years ago, around 2016, I was having a conversation on the phone with an activist, a woman activist, and she mentioned that sextortion is taking place in the war-affected districts. And that is the time then that I picked up my ears and thought that this is something worthy of research. And the research began at that time in 2016. Since 2016, we have been working, the Center for Equality and Justice, have been basically looking at documenting the cases of sextortion. And let me go back to the terminology in a little while, but basically looking at sextortion or cases of sexual bribery in the war-affected districts of Sri Lanka, but also looking at sexual bribery taking place in the justice and the health sector. So that has been our base for the advocacy that we've been doing ever since 2016. For this discussion today, I'd just like to bring in a few points that I feel are worthy of discussion in the discussion that we will have after the panel presents. One is on terminology and the fact that it's extremely important that we are clear, and I think Nancy mentioned this as well, the fact that we need to have clear terminology and language is critical to understanding what sextortion or sexual bribery is. That is one issue. The other is, I think, the role of the legal profession and the judiciary in tackling cases of sexual bribery, whether it be a case that comes to them or within the legal profession and among the judiciary as well. That is one. The other is, why is it that a sexual bribery victim survivor has a lack of confidence in the justice system. What are the reasons for that? The other would be access to justice and the fact that there are similarities or the same issues or same challenges occur when a case of sexual bribery goes to the courts and when a case of sexual violence under the gender-based violence regime goes to the court. So these are some of the things I think would be interesting to talk about here. To give you a bit of background to the work that CEJ is doing and the successes that we've had, I think one of the main things that we've been doing is raising awareness in different communities using various methods, such as puppetry, to take the message out that sexual bribery is something that we should not be tolerating among public officials. So that was one of the sort of the key sort of aspects of CEJ's work. But similarly, we found that it's extremely important to document these cases. So ever since, as I mentioned, since 2016, we have been documenting cases of sexual bribery. And that has happened we have had something like 45 cases in the war-affected districts. And we've also got 19 cases from the justice and health sector, which was a recent study that was launched a few months ago. And we feel that that is important because that is the base for our advocacy. And the fact that we have been advocating for changes or amendments to the law to bring in a specific reference or an express provision on sexual bribery. And I think this is extremely important because for many reasons. Just to give you a bit of background to Sri Lanka, the context in terms of the legal framework, we don't have a specific law on sexual forms of bribery, but we do have a Bribery Act. And within that, you have the definition of gratification, which is explained in the Act. But gratification is not explained as a sexual form of gratification in the Act. However, there has been a sort of a case that went to the courts quite a few years ago, which expanded the definition of gratification and held that gratification includes sexual forms of gratification. So that is the only precedent or judicial precedent that we have in the country. And for me, it is extremely important as a lawyer with a legal background to have express terminology in the law itself. I'm also saying that because we know that even internationally, under international law, even the UN Convention Against Corruption does not have specific terminology. And I think this is problematic. And the reason I say that is because for me, having worked with communities, having worked with the justice sector over many, many years, for around 25 years, the fact that if you don't have it in your face as a legal provision in a law, any kind of issue in the law itself, then it tends to go unnoticed. So for me, providing an express definition to sexual bribery means that there is visibility to the offense, and also you're bringing it under the anti-corruption framework, where you would bring it into bribery, because communities are familiar with the term bribery, which goes to my second issue that I'd like to just raise here, and we can have a discussion about it, terminology. And the fact that, as Nancy mentioned, and I think there has been amazing work done by IAWJ over so many years now. But I feel that we need to use terminology contextually. And the fact that in Sri Lanka, the term sextortion would not resonate with communities here, because of the fact that sextortion is used for online image sharing, sexual image sharing, and there is kind of an overlap in the definition of sextortion. So that is why in Sri Lanka, CEJ has been using, since the beginning, we have been using the term sexual bribery. That is a word that is terminology that we've been using, and what we are trying to propagate here or advocate for, even when it comes into the law itself. So in terms of the work we've been doing, and I will just go briefly into this, and we can have a discussion if you have any further questions. In terms of, we've been adopting kind of a holistic approach to our work, and that is on awareness raising, advocating for law reform and policy reforms, but also doing the research and making sure we have a base for the work that we do. In terms of the awareness raising, we believe that it's important to work with different actors. So we have been working very closely with the Bribery Commission in Sri Lanka and also with the police in terms of trying to make sure that sexual forms of bribery is taken seriously. And the fact that we need to be advocating for zero tolerance of sexual bribery in the public sector. That has been our message to the Bribery Commission over the years. Of course, initially it was extremely difficult to bring this conversation to the Bribery Commission, as you might realize. It was something that it seemed slightly alien. It was, we got the response such as, oh, this is, we don't get many cases. It's not such an issue in Sri Lanka. But over the years and with the relationship that we built with the Bribery Commission, I think there has been a sort of a change of heart. And now they are more accepting. The senior officials at the Bribery Commission are much more accepting of the fact that, and acknowledge the fact that they have a role to play here, and the fact that there is sexual bribery taking place across the board, not just in the warfighter communities, but across the island. And because due to the sensitivity of the issue, obviously there aren't enough cases that are coming to the Bribery Commission. So I think that has been the visibility that we've been able to give to the issue over the years has been extremely important, and I believe a first step to the work that we should be doing on sexual bribery. Similarly, as I mentioned, we've also kind of been doing a lot of awareness raising in different communities. And also because of the work that we've been doing across the board in raising awareness, we feel that the term sexual bribery has entered the discourse. There have been different actors, for example, different stakeholders, such as civil society organizations, and even the Ministry of Justice using the term sexual bribery. And I think this is an important development because recently Sri Lanka is in the process of redrafting or coming out with an amendment to its anti-corruption law. And what they're doing here is trying to amalgamate or consolidate 3 existing laws into one law and call it the anti-corruption law. And within that, to bring in amendments to the existing law so that we have a sort of a holistic one law that will encompass the Bribery Act, the Bribery Commission Act, and the Declaration of Assets and Liabilities Act. So basically bringing all 3 laws together into one consolidated act. So CEJ was fortunate enough to gain access to that draft bill and actually bring in sort of our ideas and suggestions for how we can include the term sexual bribery into it. And of course, looking right through it was a very, very long law, very long draft, I think, something like 100 sections or provisions in it. But we were not given too much time as well, but we were able to kind of bring in into the different relevant sections how we should be dealing with sexual bribery, and of course, having the terminology as well into the law. So I'll leave it there for now, and maybe we can have a conversation about the different developments and how we feel, CEJ feels that we should be taking this conversation forward globally as well as in Sri Lanka. Thank you very much, Nancy.
Thank you, Sharmila. And the points you raised about terminology are certainly interesting ones. There are some definite positives, as I was mentioning in my opening remarks, to having a term that everyone uses and everyone understands. Also encountered situations in which, for purely local reasons, a term is not appropriate. But at the end of the day, even in those countries, what they want to do is to relate it back to a common understanding about sextortion. And especially with, a phenomenon that really was not talked about and was not identified, we have had the opportunity to shape that conversation and to shape the terminology and to shape the way it's referred to. And so the final goal has to be that we can all talk intelligently with each other about this and know that we are talking about the same phenomenon. And so I think all of those issues are worth continuing to discuss and explore. But now I realize we're going to run out of time, and I want to be sure we have some time for audience questions. So let me turn to Macy, who is going to tell us a little more about the work that she's been doing in Indonesia around some of these issues. Macy.
Good morning. Thank you, Nancy. Ladies and gentlemen, all distinguished panels. Glad to able to see everyone in this important forum. Participants from the judiciary across ASEAN and other regions as well, representative of JFO, academics, and related stakeholders. So first of all, similar to Shamala, I would like to thank IAWJ and Jin ASEAN for the opportunity to speak in this important webinar. So let me just explain first of all of our work. I'm from USAID Integritas, anti-corruption project managed by Kemitraan in consortium with ICW, Transparency International Indonesia, and Basel Institute of Governance. What we are currently doing right now on the issue of sextortion is we're doing research. We're in the phase of finalization and dissemination process across 5 of our targeted provinces in Indonesia. And the research itself is because our project is from the perspective of anti-corruption or corruption perspective. We're trying to look at the relation or nexus of sexual relations, sexual violence or exploitation with conflict of interest and corruption. And we try to find this different dimension because our underlying topic for our project is conflict of interest. So we also look at not just not consensual relationship, which is sexual violence, but also consensual relationship that may not be automatically corruptive, but may pose a conflict of interest situation that leads to favoritism, certain privilege, and benefit for certain individuals where it may not be possible if the relation does not exist. So we're trying to look at how government institution to manage conflict of interest and a possible sexual aspect out of it and sextortion itself in their institution. So the research was started in October by our consultant and researcher, Ms. Judy Cristantini, Theodora Yunisa Putri, and Ms. Rima Angelia. So we conducted a stop study, in-depth interview, FGD, expert meetings, and public discussion. So follow up on this research, we're trying to support the government of Indonesia to draft conflict of interest guidelines, which includes sexual relation and the risk of sextortion, especially in government institutions. We will also be working on the issue with university management, staff, and students on campus integrity. We're conducting a roadshow in our 5 targeted provinces, and we'll be implementing a pilot project in different universities across our targeted provinces to develop prevention models, public education models to prevent and handle conflict of interest, which includes sexual aspect and sextortion in the university. So that's just an overall what we're currently doing and what we will be doing in the next step of our project. Some of our finding about the sextortion cases related to law enforcement agencies and judicial officers, the one that is very fascinated is that it's not well documented or recorded. So not all the cases come involving government employee or judicial officer or law enforcement agencies coming to the chamber or the judicial process. Some of it is documented through cases that being a controversy in the media, and very, very little that comes into the judicial process. For example, we found a case that a police officer changes sexual act with suspect really. So the investigator have the authority to conduct investigation and determine whether a suspect is detained or not. So this particular women suspect was asked to provide sexual act or sexual favors for this investigator with the exchange of the offer of her release from the detainment. This occurred actually in the preliminary trial when evidences and case files was transferred from investigator to prosecutor office. So the investigator offered the woman to stop in hotels or places and perform sexual acts. And because of this pressure and the fear of the risk of detainment, the woman suspect then performed sexual acts not once but several times. But at that point, and then she became realized that there's something wrong with this, and she felt abused. And then she at one point refused. When this occurred, the investigator detained her and transferred her to the prosecutors. But then the case itself was not really visible from the prosecutor's face to the judiciary process. So we have not yet obtained any data on sextortion conducted by judicial officer like prosecutors, judges, and whether there's a case where a judge there is also a case where a judge asks for prostitution service to parties in the case with the exchange of winning a case, and that is not yet also we have not yet monitored the progress of that case. So that is some of the sort of like a snapshot of what is currently what we found under our research. And so also we found the challenges and opportunities actually in terms of in Indonesian context. We see some similarity happening in Sri Lanka and also Indonesia. We see that there is also a lack of understanding, not just the public at large, but also government institution official and law enforcement agencies and also the judicial officer. So we many see this as a cases of either corruption or gender-based violence, but not both at the same time. So while we found in our research that the sextortion itself is a type of criminal offense that have an added dimension and weight, whether the criminality from the bribery offense or the added weight from the gender-based violence. So with the current existing legal framework that is applied in Indonesia, it's actually there's a gap of criminalizing these particular offenses. And then similar to Sri Lanka, we actually also have a law on anti-sexual violence and also law on anti-corruption law. Both does not criminalize and does not what they call regulate this type of behavior or criminal acts. So filling the gap of the existing legal framework, we found some of avenues or opportunities. We see that sextortion cases could be investigated, prosecuted, and then adjudicated in the criminal process as a criminal offense related to criminalized abuse of power, using force or threat, or force using an individual situation and imbalance of power with the intent to receive sexual benefits. This is actually regulated under the law on anti-sexual violence in Article 6C and also Article 12C. There is also an opportunity actually with the law number 31 of 1999 on anti-corruption law. But there is a limitation because in this existing anti-corruption law, it only criminalized graft and bribery related to what we call it tangible or economical objects. So we face the challenge of how to process this case, how to process extortion. Let's say if it's a bribery itself, who will prosecute it? Because at the moment in Indonesia, corruption case can be prosecuted by different institution or agency, where not all can prosecute both criminal violation at once. Some, like KPK, for example, can only prosecute the case related to corruption and not the gender-based violence or the sexual offense. And also, there is also the question of if it's also considered as graft or gratification under the anti-corruption law. The law mandates that individuals who receive any kind of gratification, any object as gratification, have to return it to the KPK, to the officials, because the currency or the materials of this bribery object is actually tangible object and material object. But what about if the graft or the bribery involved in the sexual transaction, sexual favors? That also poses the question how to prosecute it and how to adjudicate it. And we and also, Nancy, I think as you mentioned in the beginning of this webinar, you mentioned about the important role of the judiciary. So, as the judiciary is the decision maker of the sextortion case, for example, going into the judicial process, where there is the gap of this legislation that is insufficient, whether judges can interpret the criminal law. We have this discussion in our expert meeting from different experts coming from judges and also our investigators and also prosecutors and also academics. Some of the academics felt like actually the judiciary or the judicial office or the judges can actually conduct a rest finding or a judicial interpretation to interpret a case that is actually considered sextortion and added the sanction and not dismiss the case. But there is also from the other side of the bench, the judges who are very mostly very legal formalistic that consider judges cannot conduct judicial interpretation in the criminal law, in a criminal case, because the criminal law is very formal and there is no opportunity to conduct a judicial interpretation to handle the case. And sometimes felt like it needs to be dismissed. So also, Nancy, in terms of, maybe I'm just going to add a few more points about judiciary as an institution. They are also prone to risk of sextortion because of their very large or discretionary power and authority in handling case. So it's prone also to abuse, including extortion, sextortion. So, and this is actually not just judicial officers to the parties or defendant or other judicial seekers external of the judicial institution, but also inside the judicial institution, because there are hierarchy between different judges and also hierarchy between different judicial officers like bailiff, staff, registrar, and we see the opportunity that judicial code conduct, at least in Indonesia, could be revised to accommodate this, and not only regulating judges, but also judicial code of conduct at large for other judicial officers, like I mentioned, bailiff, staff, registrar. And we also wanted to actually ask Aci here as a representation of the court in Indonesia, whether the experiences now at the court about whistleblowing system, whether it has addressed those issues, especially for justice seeker, and also whether whistleblowing system is considered to be more administrative or substantive thing. There is also issues of protection from retaliation if it's a justice seeker that is considered in a lower level considered compared to the judicial officer. So I think that is some of the points that I would like to make, and hopefully it's clear enough to everyone. Thank you, Nancy.
Thank you, Macy. I think what it underscores is that there are so many pieces that have to be addressed in order to, at the end of the day, make effective progress in combating sextortion. And we could probably devote a webinar to each one of them. But unfortunately, we do have limited time. And I do want to hear from Aci, who does bring the perspective from the Supreme Court of Indonesia and her work there with the judicial reform team. Aci, we're running a little long, so please do try to keep the presentation brief. Thank you so much.
Thank you, Nancy. I will do my best to keep me in time, Nancy. So good morning, everyone. Thank you so much for having me in this webinar. I'm feeling really honored to participate and sharing Indonesian, in particular, Supreme Court experience in responding the sextortion in Indonesian judiciary. First of all, maybe I would like to present to you the interest of the Supreme Court, why we think that we need to respond the sextortion issue in judiciary. Our main interest, of course, we want to preserve the dignity of the judicial institution from our authority as the element of the rule of law in Indonesia. And it is the only way we have to achieve this interest is to show and prove to the public that every decisions issued by the court are made objectively and only on the basis of merit of the case. And therefore, it is important for us to remove any distraction that casts doubt on the dignity of the court decisions. And we do this in Indonesia in the Supreme Court through two mechanisms. The first one is by the strengthening the comprehensiveness and the consistency of court decisions. And secondly, by demonstrating that judges and other court members behave in a dignified manner that reflects that the noble values expected by the public from the judiciary. And it is on the second path that we encounter and have to respond to sextortion, which is part of the various types actually of the violation of ethics and judicial conduct that we want to eradicate through the supervision function performed by the Supreme Court of Indonesia. And in responding the sextortion as the form of the violation of the ethical and judicial conduct in Indonesia, we, as maybe already mentioned by Nancy and also by Shamala and Nisi, faced with a challenge that related to the difficulty to detect the indication and the information about the sextortion incident in the judiciary. It is until now, we don't have any finding when we try to trace whether we have the report about the sextortion issues in the public complaint recorded by the supervisory body of the Supreme Court and also the Judicial Commission. We found that no solid reports, and maybe Messi also mentioned that in their research, it is they're not find any findings that sextortion also happens in the judiciary. I'm not mistaken. Messi mentioned that the findings that they found maybe up to only the incident up to or committed by the police officers in the very beginning of the criminal justice process. However, of course, because we know that the challenge and the difficulty to detect this kind of violation, we are afraid that this not reflect the actual conditions. So, to respond this fact, the Supreme Court remains committed to carrying out various methods, including modifying our mechanism and system that we use to receive complaints from the public. We want that this mechanism can be more effectively in detect the violation of judicial conduct, in particular sextortion. I will maybe convey to you later the efforts are being made by the Supreme Court with the support of JIN ASEAN currently, laterally from my pointers. Maybe if we need to look at a particular case just to really review the challenge about to bring or to enforce the sextortion incident in the judiciary environment. What can I present to you is the closest, the case that have the closest indication on the sextortion in the judiciary. Maybe one case that happened in 2021. It is the case where a judge reported by his wife, who is previously a woman that submit to submit her divorce suit to the court, and at the time her current husband was the judge that examined her submission. According to the woman in her report, the judge asked her to agree to marry with him after the judge grant the approval of her divorce submission. And it is after they're married, this woman submit the report because of the judge. Then after they're married, at the initial time, the woman married, the judge married the woman with undocumented marriage process, and then they have an official one. But after the marriage being officialized, the judge neglecting the women and the children, and therefore the women submit the report to the Judicial Commission and the supervisory body of the Supreme Court. From this case, maybe we can see at least some elements of sextortion. Maybe we can say that this fulfill the elements of abuse of authority and maybe quid pro quo or something for something element that required in the sextortion. But even so, I think some parties still might want to debate whether the third element of the sextortion, which is the psychological coercion, also exists in this case. So therefore, it's still debatable actually whether it is sextortion or not. But maybe in this debate, I want to invite everyone to maybe also to look at the unequal power relation between the women during her divorce case with the judges who has the authority to approve or dismiss the divorce that she was filing at the time. Even though it is only one case, we quite a relief that finally we are able to settle this case with the support of the Judicial Commission, and now the judge already received sanction and dismissed from the office permanently. And maybe to also to respond basic question, as I said earlier, the Supreme Court is very concerned and serious about detecting and finalizing the disciplinary action of judges for sextortion and other forms of ethical and judicial conduct violation. To detect it, we have a challenge that many of maybe victims, if there are any, or also witnesses from the member of, whether it is from the external or even the member of the judiciary itself, is reluctant to report because they are afraid of the retaliation after they made the report to the supervisory body or other institution like Judicial Commission. And the second one, we also have feedback even from the internal member of the judiciary itself, that even though they know something, information, indication about violation of conduct, of course, maybe including the sextortion, if it is taking place, they're not really sure about the follow-up and the settlement can be made by the Supreme Court or other authority, whether this judge offender would receive proportional sanction maybe after they are being reported by the witnesses or by the victims. And to respond this challenge, we are now revitalizing our what we call it, our electronic or online system to receive public complaint, either it is from external and internal of the judiciary, just to make sure that we can accommodate better, in particular to enhance the mechanism of whistleblowing, because during this revitalization, which is supported by the JIN ASEAN, we found that the mechanism of whistleblowing that actually already in place since 2016 in the Supreme Court, the mechanism is not really effective, because since it was established 6 years ago, we found that the Supreme Court never have any submission or report about judge allegation of judge misconduct that can be handled with the whistleblower mechanism. I mean, even no one or none of complainant asked for or asked to use the whistleblowing mechanism because they are not sure whether the system that actually exists and provided by the Supreme Court can be worked effectively. So we found that it is, and during the evaluation, we found that it is quite reasonable because the current whistleblowing mechanism in the Supreme Court still collected or done collected some personal identification of the complainant. So once every complainant try to submit the report, they will be alerted that it is not really secure for them, and they will be worried of retaliation by the reported judges. So in a more simple way, I can say to I can respond to Messi and everyone that our current mechanism of whistleblowing still not meet the standard requirement of the whistleblowing mechanism that can protect the complainant or the reporter from the retaliation or other action from the reported parties. And as the second approach that we use to respond the lack of confidence of the justice seeker or other member to submit their complaint to the supervisory body is to convince them that every report or every indication of judge violation misconduct will be followed up properly by the supervisory body and also be and can be imposed by a proportional sanction. And it is we done through the publication of the judge disciplinary sanction every 3 months in the website of our supervisory body and also in the annual report of the Supreme Court. It is the way we try to show to the public that their report matter and we do our best to make a correction and to make sure everyone accountable for misconduct violation will be responsible for their act. And just to respond other challenge in Indonesia that raised, it is true, I think, yeah, that we still have also a challenge in Indonesia to bring the sextortion or other sexual or gender-related misconduct violation to the criminal justice process. I mean, I don't know, maybe it's quite specific or unique in Indonesia, but sometimes it is easier for us in the Supreme Court to prove that a judge is guilty and can be imposed with sanction, disciplinary sanction, instead of to bring him to the criminal justice system, even though maybe her act constitute also a crime. One case that maybe can be a good example is in 2013. There was a judge that bring to the court by our Corruption Eradication Commission for the bribery and gratification related to a case that he was examined at that time. During the investigation by the KPK, they also found that this judge receiving a regular sexual gratification related to the case. But once I checked with the decision for the case is examined and being what we call it, yeah, the court decision being final and binding in the first instance of court. And when we check the decisions, the prosecutors, we find that the prosecutors didn't use the fact that this judge received the sexual gratification as one of the elements of his bribery act. So it is unfortunately because judge cannot review any act or impose any crime sanction without the prosecutor mention or elaborate the act in their indictment. So it is maybe one example completing that Messi raised about our challenge in Indonesia. And I am happy to know about the research now conducted by Messi and her colleagues in Kemitraan. And it is also, I think, very relevant if one day in Indonesia we have the conflict of interest guidelines, because in judiciary, in our observation, the most challenge not only to keep our independence from other branch of the institution, but to keep our impartiality, the judge impartiality that commonly caused by their conflict of interest for various reasons. Maybe that's all from me, Nancy. I welcome any inputs and questions from the audience.
Thank you so much, Achi. Listening to all of the comments, it reinforces for me, one, how important it is to wrestle with all of these different issues as we're doing in this webinar, and how it's not surprising that there are still so many unanswered questions. Because when you think about it, this concept is still relatively new. And being able to address sextortion starts with awareness, understanding what it is, understanding that it might be something that is wrong, understanding that it might be something for which there is redress. And I'm always reminded of a brochure, a really wonderful public education brochure, but it said sort of, what is a bribe? And then listed half a dozen different things like gifts and cash and votes, and I can't remember what had hampers of food, but you looked at all of these things and not one of them could have been construed as encompassing sextortion. And, this was a brochure put out by the Anti-Corruption Agency. And you think if you were a person who had just experienced a demand for sexual favors, how would you know that this might be seen as corrupt? How would you even know that you might have something to pursue? And of course, until people pursue these claims, until they lodge complaints, the courts won't even have an opportunity to consider the cases. And it's really interesting to me to hear, and exciting, that people are trying to research this and trying to track down instances of sextortion. And that is an important stage in ultimately being able to combat it effectively. Because then the next step is, when someone understands that they have a possible wrong, an injustice for which there might be a remedy, are they going to feel empowered to complain? And I think people have touched on all of the barriers that exist and how hard it is to have complaint mechanisms that feel safe, where people won't be retaliated against. I mean, almost by definition, the person who is abusing his power is more powerful than the person who is the subject of the abuse. And the risks of retaliation can be very, very real. So looking at what we can do to lower some of those barriers, once we've raised awareness, at making women comfortable in coming forward so that the courts even have a shot at dealing with these issues. And then, of course, when they get to the courts, the fact that for many years, people were not focused on this. So it's hardly surprising that our legal frameworks are not very explicit about sextortion or sexual favors. And I frankly see it as kind of a mixed thing to have broad language, because after all, most anti-corruption statutes don't detail all of the different types of inducements that might be offered to someone in exchange for, access to exercise of that person's authority in a way that would be favorable. And yet we have no problem applying that language to the full gamut of benefits. It doesn't specify in exchange for a car, but if someone has offered a car in exchange for getting the government contract, we have no difficulty finding that that was corrupt and that was a bribe. But it is interesting because when you get to sextortion, I did a workshop in Tunisia, where Tunisia has a very broad anti-corruption statute. In fact, it has language that is in effect, any benefit of any nature whatsoever. And yet in this room of anti-corruption officials and judges, there were some people who were perfectly content to construe that language as applying to sexual favors and not needing anything more explicit. And there were others who were concerned that it didn't provide specific enough notice to potential defendants that what they had done was wrong and potentially criminal, would make them criminally liable. I think I personally tend to the view that it takes a while for the law to catch up with these things, and we need to use every available avenue to try to hold people accountable in the interim. I noted in the chat that someone talked about the plethora of laws in the Philippines that can be used to combat this. And one of the potential roles of judges is, in fact, to be, I don't want to say creative in a pejorative way, but in a positive way of using the power of the law to its fullest extent to hold people accountable for things that are clearly wrong. And we've done surveys with the International Bar Association and others in various jurisdictions. And almost every jurisdiction has some laws that can be applied to this. But you need the awareness that this is a problem. You need people to come before you with complaints, and then you need judges who are willing to apply those laws to hold people accountable before we can begin to make any progress. And I think our panelists have really touched on this whole chain of things that need to happen. And they are changing, they are happening. And both NGOs and judges are leading the way in raising awareness about this and doing something to address it. But until all of the pieces fall in place, we won't have ended sextortion by a long shot. I am mindful of the time, and I do want to be able to answer a couple of questions from the audience. So let me just pose one quick question to our panelists, because we do want to sort of connect back their experience in combating that with what the judiciary can do, and sort of ask them very briefly if they had one message to give to judges about this issue. What would that message be? Macy, do you want to go first?
Yeah, thank you, Nancy. I think the most important thing, because of that limitation in terms of our legal framework, and judges tends to be legal formalistic, especially in criminal cases. At least from my perspective, from our perspective as the public, is we hope that judges is able to respond issues, sextortion issues, as best as they possibly can with their limitation, right? So one is to have a judicial interpretation or as finding, you may call it, when looking at the cases, not just from the short, narrow gender-based violence or short, narrow perspective from corruption, but corruption offense, but both. And then looking at it objectively, looking at the perpetrator and also both of the perpetrator, whether there's a victim element on it, whether there's pressure, especially in corruption cases where sometimes the women, the sexual transaction or the sexual services is just merely like an object for the bigger and the mastermind of the corruption case. That's one. The second thing is that the thing that they can do actually, because of the judicial code of conduct that is currently not legislation. It's internal regulation where the court can actually revise them. They can issue guidelines for their own internal institution too, and then they can also educate them because they have a training center where they can train new elected judges, justices, and also officials like the bailiff, the registrar about this. And then all of this action is actually does not require a revision the law or drafting a new law. It can be done internally. The third one is about the whistleblowing. The whistleblowing system, where it can also protect not just processing it as an administrative, referring it to the investigator. For example, if this case is inside an ethical committee, it should not end just by dismissing the particular judges or judicial officer, but it also have to be forwarded to the authority, to the police, so that criminal sanction for these people can be brought to justice. Then, so that people are like victims or complaints could be made that they felt that there is an ending or a benefit outcome out of it, not just being in the position of uncertainty about their own protection, but their own career and the future. Like if someone is reporting the judicial officer, the judges, about a particular sextortion happening inside the court, it's really hard for us to convince them to report. That's one. The second thing is that whether there's a beneficial outcome out of it. A dismissal, I don't think a dismissal itself is enough. There should be a prosecution, and then what we call the stance of there's no impunity. If there's someone, a judge, let's say, is dismissed, also the judicial officer or police officer, they're dismissed, but there's no criminal cases being brought up about their action, that could also sort of like deter victims to come forward. I think some of those things that is actually an opportunity, policy that the court itself and other law enforcement agencies can do should be done. Right. Thank you.
Thank you. Shamala, what would you say? What would your message to the judiciary be?
Yeah, so I have many messages, but I'll just maybe stick to a few. And I think Messi took one of my messages, but that's fine. I think one of the things to kind of look out for is, and also for the judiciary to be aware of, is the important role that the judiciary plays in creating precedent and a body of jurisprudence on sexual bribery. I think this is extremely critical. And for that, obviously, you would need to have a proper understanding of what we're talking about here to bring sexual bribery under an anti-corruption legal framework. I think that's also important. So, and I also believe that when you look at the fact that if you're building a body of jurisprudence, it also means that that would help or assist calls for law reforms to address sexual bribery in legislation. So having a body, a rich body of jurisprudence whenever it's possible and whenever a case comes, it comes to the court on sexual bribery, that you deal with it and you kind of make sure that there are, all avenues are also kind of included, all different perceptions, etc., included in your judgments. For example, I think it's really important that international law is included in your judgments. I do know that in Sri Lanka, when we reported to CEDAW in 2017, we submitted a shadow, CEJ submitted a shadow report and on female heads of households affected by war, and the fact that sexual bribery was something that they face. The concluding observations of the CEDAW committee actually mentioned this. So I think it's really to bring about legislation to address sexual bribery in Sri Lanka. So I think these kinds of examples would be useful to put into case law. That is one. And the other is, I think, to look at the supervisory role of the judiciary. What is the role the judiciary plays in regulating the behavior or misbehavior of court employees and the judges themselves. So I think that is something that needs to be also looked at. Yeah, so I think I would stop there. So basically a clear understanding of the anti-corruption framework and how sexual bribery fits in, the role of judiciary in creating a rich body of jurisprudence, and of course the supervisory role of the judiciary. And the critical importance of all these roles, I think, would be something I would give out as a message to the judiciary. Thank you.
Thank you. And Achi, what would your message be?
Yeah, thank you, Nancy. Maybe I would like to give emphasis on what Messi already mentioned about the needs to educate our judges, in particular, maybe our supervision officers in our supervisory body, but how to handle and respond complaint about the sextortion. I also want to ask us to reflect and maybe think carefully again about the pro cons to use the or not to use not to adopt completely the element of sextortion, maybe in a more coercive legal framework. I mean, right now, if we evaluate the judicial conduct in Indonesia, it is quite regular. Maybe I can say that it is gender neutral, maybe, and it is not really helpful actually to make the judge have a better perspective on gender-related misconduct when they're doing the supervision function. But in other part, I also think that if we make the code of conduct or other disciplinary regulation in the Supreme Court in a more what we call it, a formalized one, adopting all the sextortion elements that we discussed, maybe we will have the supervision officer will be have more heavy task to prove that, for example, the judge committing misconduct or sextortion. I think the case that I already mentioned earlier about a judge that asked women when she submit her divorce case to marry with him is one of the example. And the second one, maybe the last one, yeah, the one that just to complete the message from Messi and Saimala. I think it is also still a very big homework for us in particular, for in the Supreme Court of the Indonesia, to equip our supervisory body to have a more effective supervision function to almost 9,000 judges, while the officers in our supervisory body only less than 50%. And the second one, besides maybe the lack of gender perspective education to our officers, we also need to provide them with the knowledge and skill on the technique that specifically needed to use when they investigate gender related misconduct, because sometimes it is very specific action or attitude that actually indicates something related to sextortion or sex bravery, but because of the lack of knowledge and skill that we have with our officer, that can they finally not can prove the guilty of the reported judges. Maybe that's a message from me, Nancy. Thank you.
Nancy, you're just on mute there. If you want to unmute yourself.
Thank you. It was blocked by the chat box. Thank you, Achi. I wanted to take at least one audience question, and I saw actually one in the chat that I would like to answer very briefly, which relates to whether sextortion is only a male in a position of power extorting sex in effect from a female, and the answer is no. I mean, some of the examples I gave involved male victims. I have yet to come across a situation in which a woman has been the abuser, has been the person in a position of authority, but certainly there is nothing about the concept that would preclude that. Basically, it's a question of power relationships and vulnerability, and not strictly of gender. The intersection comes because gender is a factor in vulnerability. But another question that came in had to do with the fact that because of the quid pro quo nature of sextortion, the the victim survivor may be reluctant, if she accedes to the pressure for a sexual favor, to come out in the open and admit that. You know, there's a lot of stigma and shame associated with it. If she doesn't accede to it, often she may not even come forward with a complaint, because after all, she didn't accede to it. But part of the education effort is making people aware that even in those situations, the demand was inappropriate. But what can one do to protect victims who are reluctant to come forward because of that quid pro quo element? Is there someone on the panel who would particularly like to answer it? I know, Macy, you had raised concerns about whistleblower protections. Perhaps you would like to do so.
I think, Nancy, thank you. I think there's also an issue of, well, an investigator can actually not defer a case, but they can actually prosecute for a more lenient sentence. That's one. Second thing is that I heard during our FGD with Government of Indonesia representative, one of them were prosecutor in the corruption case where the woman that be providing these sexual favors and sexual services as the bride was actually not being prosecuted because KPK aims is actually the mastermind, the ones that benefit out of the sexual transaction itself. So maybe also looking at not deferring the case, but sort of like, I don't know the correct term. In Indonesia, there's a diversion, like like not prosecuting a case where this happened, and then that could also provide especially victims, whether women or men or other genders, that give them the safety that even if there's a quid pro quo and then they're involved in this transaction, that because out of the imbalance power and pressure and the fear of not coming forward will be will not happening, right? Because if let's say in a bribery case, if a person who's becoming the object of the sexual transaction, they will fear their own prosecution in a sexual offense, for example. I think unfortunately there's a limitation on how far diversion is. Right now Indonesia is only limited to offenses related to minors or children.
Thank you. Thank you so much, Macy. And Sarah, I think I probably need to turn it back to you. I'm mindful of the clock, but it has been such a pleasure to talk with everyone today and to the benefit of all of these different perspectives about sextortion. We have a lot we still need to wrestle with in this area, and IAWJ looks forward to partnering with you in that effort and continuing these conversations.
Thank you very much, Nancy. And I really want to extend a really warm thank you to the panelists. Obviously, it felt like we just got going there in that conversation, and looking at some of the chat coming in, the ideas on the last one, maybe this next time it needs to be a full day conference where we have a chance to actually get into these conversations. I do think, as much as that, I hate to be the one cutting it short today, it's a great sign that we're talking about this and thinking about it. The research is being done, the innovation is coming through models like we're seeing in Indonesia, that it's actually a window in which I think we can plan for and look for that next level of engagement on this. So let's treat this as just the introduction. Thank you very much to each of you. As always, I also want to make a thank you to the funder. Jin ASEAN is supported by the US State Department, who's particularly interested in and paying attention to sextortion as a part of anti-corruption efforts, and I appreciate that. I'm just sharing in the chat for everybody 2 resources, one that Jin ASEAN has produced and one that AIWJ has produced that you can access if you want to think a little bit more about gender issues, period, in judging, as well as sextortion particularly. I'm also going to add two links now. One is if you want to sign up for the Gymnasium newsletter. And the second one is people who are interested in becoming members of IWJ. Please take a look at those links. The role and the leadership of judges across the region in connecting with each other, helping to have these conversations, to take those courageous steps internally to raise these issues and call out patterns is really important. And finding ways to connect with your peers, I think, is one of the ways to do that. Finally, we will be sharing shortly an evaluation survey, and we really welcome all of your feedback. You can see the link has just been put in the chat. I think you'll probably receive a follow-up from the Zoom connection, and we always welcome your comments about the event, and that will help us shape the next one. I finally, again, thank you all. And I know that not all of those questions were answered. We will go through the questions and find ways to continue to address some of these things in the Gymnasium newsletter as it comes each time. It comes out about every 6 weeks. And so maybe watch for some more follow-up there. Have a wonderful day across all of your time zones as you head off to engage in this important work on your own. And thank you very much. Have a good day. Bye-bye.
Thank you, Sarah. Thank you, everyone. Thank you, Nancy.
Thank you.
Nancy. See you, everyone.
Jamala, Nancy. And
Thank you,
also
everyone.
Sarah. Thank you.